Hey, what's up? This is Mr. Ippolito, and we are going over Bill of Rights scenarios. Now, in order for us to be watching this video, you should have already attempted all 12 of these front and back of the paper. If you haven't yet, then you should pause this video and you should take 10, 12, 15 minutes or so to at least attempt, and you can work on this with somebody else, attempt to work these out. Now, you're going to work these out with the help of the Bill of Rights. Now, this one is the most convenient because it's right there on your desk, hopefully, and a one-pager that you can see all at a glance. But this is also in your pocket constitution that I gave to you. It's in the textbook. It's, in a lot of different places, but this is the most convenient place to work on this. So once you've worked on this, or at least attempted all of them using this, now we'll go ahead and get started. Now, the first scenario, this Sarah, this 18-year-old college student, she's arrested for stealing a classmate's term paper, selling it on the internet. When she appears before the judge, she asks for a lawyer to help defend her. The judge says, you know what, if you're smart enough to attend college, you're smart enough to defend yourself. Besides, she's not being charged with a felony, so the stakes aren't very high. Are Sarah's amendment rights being violated? Are her rights as an American being violated? And if so, which amendment is it? So in this particular case, it is the Sixth Amendment. So if you look right here, one of the guarantees of the Sixth Amendment, and you notice that all of them have Roman numerals, right? They're often expressed with Roman numerals, but that just means the Sixth Amendment. So this is a little practice with Roman numerals as well. One of the guarantees that you have is the assistance of counsel, right? That basically means you have the right to an attorney if you're accused of a crime here in the United States. So yes, the judge was violating her rights. And so if you said the Sixth Amendment, then you're absolutely right. And let's move on now to scenario number 2. Jackson was playing baseball in his yard, accidentally hit a baseball through his neighbor's window. The neighbors, the Wilsons, asked Jackson's parents to pay for the damages, but they refused. The Wilsons take the case to court. The judge denies their request for a jury trial because the damages were only $350 and said it would be a waste of a jury's time over a neighborly dispute. Is this violating the Wilsons' constitutional rights? In fact, it is violating their Seventh Amendment rights. Now, this doesn't come up very often because, back under the Constitution, $20 was a lot of money. Today, that's every lawsuit. If you're suing someone for less than $20, you're wasting everybody's time. But if your lawsuit is more than $20, then in the Bill of Rights, according to the Seventh Amendment, you have the right to a jury, a civil trial by jury, right? Which basically means you're suing someone. That's in civil court, as opposed to criminal court when someone's being accused of a crime. This is civil court where you have a lawsuit, one party versus another party. And so anytime it involves $20, and civil lawsuits always involve over $20 today, then it's going to involve a jury trial. So there you go. All right. And by the way, if you ever watch any of those like court TV, the like Judge Judy or any of those kind of shows where a judge just rules on their own, that's because both parties have waived their rights to a typical court under the law, right? And they've agreed to both have their dispute settled in TV court. So if you're wondering, hey, wait a minute, there's no jury on Judge Judy or the People's Court or one of those other shows, those court shows, that's because it's made for TV. Okay. Scenario 3. Whoops. Okay, well, Carolyn is arrested for shoplifting a candy bar from a neighborhood convenience store. At trial, she is found guilty. The judge decides that the appropriate punishment is to cut off Carolyn's hands so that she will not be able to shoplift again. I went ahead and I threw the answer in there. The answer is the Eighth Amendment, which bars the government from inflicting any cruel or unusual punishment or giving any excessive bail that would not fit the crime, right? So in this case, in our country, we have never used torture or, cutting off people's hands. That has happened in human history, but it has not happened in the history of the United States where cutting off someone's hands has been punishment for somebody, committing a crime, any kind of crime. But there are still places in the world where you actually can get physically punished for certain crimes. So let's go ahead. You're gonna take a quick pause from me, and let's go ahead and watch.
The first time I got 9 strokes, I couldn't sit down, I couldn't sleep on my back. But subsequently, when I received the 7 strokes, I was playing basketball on the day itself that I was caned.
This is Darren Tan, a lawyer who has been on the other side of the law. He's passed through the prison system and emerged after receiving 19 strokes of the cane. His crimes: gang-related activities, drug trafficking and drug consumption. each warranted 5 to 9 strokes of the cane. Caning is a practice many in Singapore are familiar or even have personal experience with. Whether it's naughty children, rebellious students, or people who find themselves on the wrong side of the law, the question has remained: to cane or not to cane? Caning has been used as a form of discipline and punishment for hundreds of years all across the world. The bamboo cane was used in ancient China as one of the 5 capital punishments. In 18th century Europe, there was birching. The East did it. The West did it. And so did everyone in between. But somewhere along the lines, people turned their backs, pun intended, on caning. And Singapore became one of the last few countries where the rotten stick continues to be used judicially and in homes. Let's begin by taking a look at what offences warrant corporal punishment in Singapore. According to Article 88 of the Education Act 1957, light caning on the palms or clothed buttocks can be applied to male students who break the rules. And according to the Penal Code 1872, caning can also be applied to men who break the law.
Generally, violence against persons, also certain offences that are abhorred by society, or it's just a matter of state policy. So things like drugs trafficking, vandalism, and even certain immigration offences. For robbery during the daytime, the mandatory minimum is 6 strokes. But if it's nighttime, then it's 12 strokes.
And is anyone exempted from judicial caning?
Women, men who are above the age of 50, accused persons who have been sentenced to the death penalty.
That was fascinating, right? Well, so as you can see, once again, I just want to reinforce, here in the United States, we do not do physical punishments, like any kind of beatings or anything like that for crimes. That happens still in other countries, but not here in the United States. Okay, scenario number 4, James is an avid hunter. However, he recently has been seen associated with known local gang members. Authorities believe he may have begun the initiation process of joining a gang. A team from the ATF, that's the Federal Bureau of Alcohol, Firearms, and Tobacco, although that should be flipped, alcohol, tobacco, and firearms, stormed his house and confiscated his hunting rifles, claiming they were gang-related. Does this violate James's constitutional rights? Well, as a matter of fact, it does. It violates 2 amendments. If you recall up at the top, at the directions, I said, hint, in one scenario, there are 2 amendments that apply, and this is the one where the 2 amendments apply. So, first of all, this is a violation of James's Second Amendment. He does, as long as he purchased those guns legally and has them legally licensed in the state in which he purchased them, then he is legally allowed to have those rifles, and those rifles have not been used in the commission of a crime. Then he is allowed to keep those rifles. Cops just can't, no law enforcement agency can just barge in and take his hunting rifles. So that is a violation of his Second Amendment rights and also a violation of his First Amendment rights. This is specifically the right of people to peaceably assemble. This has actually gone to court where gang members have actually sued because there have been what are called these gang injunctions, where essentially, like the city of Los Angeles, for example, would try to make it so that gang members couldn't congregate, known gang members couldn't congregate. But the court said, you know what, you're violating their civil rights. You're violating their First Amendment rights. And you can't, even if they're known gang members, if they're not in the progress of committing a crime, you can't make it illegal for them to hang out, to peaceably assemble. So, therefore, James's Second Amendment rights and First Amendment rights were being violated. And now let's move on to scenario number 5. Carter, upset by recent government actions, decided to burn the American flag outside of his state capital. Carter is arrested and given a small fine and a short jail sentence. Can the government do that, or is the government violating Carter's rights? What did you say? Well, the correct answer is yes, they are violating his First Amendment rights, because it was actually, and I wrote this down, it was in a Supreme Court case called Texas v. Johnson, where it was found that the Supreme Court ruled that burning a flag is considered freedom of speech, and therefore no one can make a law, either the United States or any individual state cannot make a law that would violate your freedom of speech, which includes the freedom of speech to burn a flag if you wish in protest of the United States. All right, so that was scenario number 5. First Amendment rights were violated. Let's move on to scenario number 6. Thomas, a 13-year-old student, wears a Make America Great Again hat to school. The principal pulls Thomas aside and asks him to please not wear the MAGA hat again because it is offensive to some students and therefore could be disruptive to the learning environment. Thomas wears it the next week and is suspended from school for 3 days. Well, which amendment is at play here? Of course, it is the First Amendment. But are Thomas's rights being violated? Well, actually, there's a similar story about this high school student right here that is part of a larger video piece that I'm about to show you. So let's go ahead and see if, in fact, can a student wear a MAGA hat to school? Let's see if we can find the answer. Let's watch this to learn more.
Here at Education Week, we've been digging deep into how to improve K-12 civics education. But one thing's really puzzled us. If the U.S. Constitution is the core document guaranteeing Americans' rights, what does that mean for students? There have been a lot of U.S. Supreme Court cases that have taken aim at bits and pieces of this question, but it's still pretty complicated.
I am a law professor at the University of Chicago, and I've written a book called The Schoolhouse Gate. Essentially, it's about how the Supreme Court has shaped the nation's public schools by identifying and protecting students' constitutional rights.
With Justin's help, we looked at 4 examples of rights that assume different contours for students when they're in school. We also tested our colleagues to see what they knew.
Do you know if students can wear clothing or say things that other students might view as offensive?
Yes, under freedom of speech, I believe they'd be able to do that.
I think it's up to the principal's discretion.
In the famous Tinker versus Des Moines ruling from 1969, the Supreme Court recognized that students maintained some free speech rights. It ruled that students who wore black armbands to protest the Vietnam War engaged in protected political speech. It famously said that free speech didn't stop at the schoolhouse gate. Here's the wrinkle. Since 1969, the court has recognized various limits to student expression. In a current free speech lawsuit in Fresno, a student sued after administrators told her that her MAGA hat ran afoul of the school's dress code, which permits only school logos. We don't know how a district court or the Supreme Court might decide on whether wearing this hat is protected or not, but we do know that generally free speech for students is limited in a way it's not outside of school.
What would you think if a student was randomly drug tested as part of participating in a student club?
I would doubt that that would be legal.
I feel like it would be legal, but they'd have to sign a form of consent.
The Fourth Amendment means that the government and the police generally can't search your homes or your belongings or force you to take a drug test unless they have a warrant or probable cause. But to a large extent, that doesn't include students. School officials generally only need to have a reasonable suspicion to search students' belongings for evidence that they broke school rules. And it's okay to require students to take a random drug test as part of school sports or clubs.
That is distressing to me because that is a dragnet search where the government is sweeping up all sorts of information, and the likelihood of being able to find wrongdoing by any individual student is quite low, and so that's really distressing.
It's not always clear when a search suddenly moves from permissible to excessively intrusive.
Do you know whether paddling students is still legal in the U.S.?
Ooh, paddling students. That's a throwback idea.
I'm scared now that it is, but it should not be.
But I do know because I used to live in the South and it happens all the time. So, yes.
The U.S. military ended flogging in 1862, and all states had ended whippings as a judge-ordered punishment by the early 1970s. But surprisingly, the U.S. Supreme Court has repeatedly upheld paddling for students.
There are 18 states that currently permit corporal punishment, but in some respects, that overstates its prevalence because just 5 states account for more than 70% of the instances of corporal punishment, and those 5 states are all in the South, and it will come as no surprise to many that students of color receive a disproportionate share of corporal punishment. So I hope that this issue is able to be revisited.
We've looked at 4 different amendments, and we've still only scratched the surface here. But the overall thing to know is that while schools are supposed to educate kids about the U.S. Constitution, they're also permitted to curtail some of students' constitutional rights. Also, there's no real roadmap or checklist for educators on how to balance kids' rights with their own teaching mission. It's a big challenge for schools without a clear answer.
Well, so after you're done with that piece, you may be wondering, wait, Mr. Ippolito, we didn't get an answer on that. We didn't get an answer to what happened in Maddie Muller's First Amendment case. Well, I hate to disappoint you, but I don't have an answer either, for one of two reasons. Either because I think this was a 2018 case. Sometimes cases take 2 or 3 years, especially with COVID. Sometimes cases take a while to get through the courts. I was trying to find news articles, and not right now, but later on after class, you could Google Maddie Muller MAGA hat or Maddie Muller First Amendment, excuse me, and you could try to find out for yourself, because I was not able to find out the result. I tried to do a little bit more research. I did find Maddie Muller's Twitter account, and her last tweet was on February 6, 2020, when she tweeted, "Trump is still your president." And that was the last tweet on her account. And I'm at a dead end. But if you find out more information, and if you can find out whether or not she did a court rule that her First Amendment rights were being violated when the school told her you may not wear your MAGA hat to school, I don't know. But if you can find out, I would love to find out from you. So you could do a little bit of research on that on your own. Okay. We're going to be in class later on this week. We're going to be learning more about your freedoms, rights and freedoms as they relate to in school, because they're a little bit different outside of school than they are in school. We're going to be learning more about those in a future class. Anyway, let's go ahead and move on now to scenario 7. 16-year-old Ryan is the captain of the football team. Before the Friday night game, he and his teammates are required to submit to a drug test. Ryan's test shows traces of marijuana. Now, before we go any further, you might say, well, Mr. Ippolito, marijuana is legal in California now, to which I would respond, you are correct. Recreational marijuana is legal for people over the age of 21. So 16-year-old Ryan is still very much under the age of 21. He is not allowed to participate in the game, and he is suspended from school. Is this a violation? First of all, which amendment would this deal with? Well, this deals with the Fourth Amendment, which is the people's protection against unreasonable search and seizure. But in this case, Ryan's Fourth Amendment rights are not being violated. The courts have supported when schools do random drug testing of student athletes, because the courts have said that it promotes drug-free youth. And we don't want our teenagers to be using drugs. And that includes marijuana, because here in California and other states, it's legal, but it's legal for 21 and over. So random drug testing of student athletes, or required drug testing weekly or biweekly of student athletes, is perfectly legal and does not violate a student's Fourth Amendment rights, according to the courts. Okay, moving on now to scenario. So the amendment involved is the Fourth Amendment, but is it a violation was the government violating Ryan's Fourth Amendment rights? In this case, no, not a violation. And the school is allowed to do that. All right. Scenario number 8, a known drug dealer is arrested for suspected connections to an inner city murder. The police do not inform him of his rights, but instead immediately begin to interrogate, that means question, him. They continue to interrogate him for hours until he finally admits he knows the victim of the crime and was in the neighborhood where the murder took place. So now he's a suspect, and if it is found that he is involved, then he could be convicted either of committing the crime or being an accessory to the crime. And here was another one where I forgot to get rid of this. And so I think, yeah. Oh, okay. So let me just explain it. So first of all, it is, his Fifth Amendment rights were violated for sure, because you may not be compelled in any criminal case to be a witness against yourself. In other words, you can what's called plead the Fifth Amendment, right? You have the right to remain silent, and that is your Fifth Amendment right. So he was not aware of his right to remain silent. He should have been informed of his right to remain silent. He was not informed, and so he unwittingly became a witness against himself, which is not allowed. Now, you could also argue that he should have had an attorney, or he should have known that he had the right to an attorney. And any good criminal defense attorney would have said, dude, shut up. You should not say anything if you're accused of a crime. If you're arrested, you should just keep quiet. Even if you're being interrogated and you think you might be arrested, you should just stay quiet. So any good criminal defense attorney would have said that. So you can certainly make an argument for the Fifth Amendment. You could kind of make a lesser argument for the Sixth Amendment, but this is for sure even though he is a known drug dealer, even drug dealers have constitutional rights, and his constitutional rights were violated because he was not told that he had the right to remain silent. Okay. Moving on now to scenario number 9. Your parents are very religious people, but you are not. Today, your parents are going to a service at their place of worship, and they expect you to come along. You refuse. They make you come anyway, and then they ground you for the following month for being an unruly child. Are your rights being violated? First of all, which amendment would be involved in this? Well, it would be the First Amendment, because you do have the right to freedom of religion. Freedom of religion includes the freedom to not practice any religion at all. However, the First Amendment is a protection against the government. It is not a protection against your parents. So if your parents make you go to church, or make you go to temple, or make you go to a mosque, or make you go whatever religious place of worship, then they're your parents. You got to go with them. So this is not your parents forcing you to participate in a religious ceremony is not a violation of your First Amendment rights, because they are not the government. The First Amendment, the whole Bill of Rights, protects you against the government, not against your parents. I will also, in a related note, I will also say that when President Trump, if you recall, shortly after the January 6th insurrection, President Trump had his Twitter account taken away, his Facebook account taken away, I think his YouTube account taken away as well. And President Trump was very angry. He said, my First Amendment rights are being violated because I have freedom of speech, and how dare you take away my account? Well, Twitter is not the government, Facebook is not the government, and YouTube is not the government. And so neither Twitter nor Facebook nor YouTube were violating President Trump's rights when they took his social media accounts away from him. Now, President Trump, if he wanted to, he could sue in a civil court. Remember earlier we talked about the difference between civil court and criminal court. So President Trump, if he felt that the terms of service, if he felt that the contract that he entered into, a business contract, a business relationship, and President Trump is well known for many, many years of being a very astute businessman. If he felt that the contract was violated between him and Twitter, him and Facebook, him and YouTube, then he could file a suit in civil court, suing Facebook or Twitter or YouTube for unfairly denying him service. And so I believe he threatened to do that, but he never followed through with the lawsuit, because I think it was pretty clear that President Trump violated the terms of service for Twitter and for Facebook and for YouTube. And then that's why his accounts were taken away from him. And his First Amendment rights were not violated, because, again, it wasn't the government taking away his Twitter, Facebook, YouTube. It was private businesses, Twitter, Facebook, and YouTube, that were doing it. So, again, the First Amendment only applies if the government is silencing you, right? Or violating one of these other rights here. A recent spike in patriotism across the country has led to the recruitment of thousands of new military recruits. Because of the increased numbers, the provided barracks at military bases cannot house all the new soldiers. In response, Congress passed a law requiring married empty nesters. An empty nester is someone whose parents whose children have grown and moved out to house 1 to 2 soldiers with compensation. And of course, this is a violation of the Third Amendment. The government never does this. So why was it so important to the founders, the framers of the Constitution, or in this case, the framers of the Bill of Rights, to include the Third Amendment? Well, of course, it was because of the Quartering Act, right? Because they had just gotten out of a very abusive relationship with Great Britain, and King George III was housing soldiers in colonists' homes. And so they wanted to make sure that this didn't happen. And so, the government doesn't do that today. Now, I will say that if it were in a time of war, then the government could do this if they needed to. We've never needed to, though, because most of the wars we participate in are in other countries and not in our own country. So, but you see there, the Third Amendment says no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So in a time of war, Congress could pass a law, saying this is how soldiers are to be quartered in Americans' homes. And I think that most Americans would be fine with that, because if we're under an invasion or attack, then we want to do whatever we can to support our troops. So that's the Third Amendment, and really no Third Amendment cases ever really get to the Supreme Court. Some attorneys will try to argue Third Amendment to kind of argue other related cases, but it's not necessarily like soldiers. Okay, moving on. Scenario 11, to promote and encourage more young Americans to attend college, technical school, or the military, Congress passes a law called the Marriage Age Act, which states you cannot get married in any state until the age of 21. And this may be a little bit more tricky, but this, as you may have figured out, violates the 10th Amendment, right? The 10th Amendment says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states are reserved to the states respectively or to the people, which basically all that means is the powers that are in Article 1, Section 8, which you've already learned about, the powers of Congress, powers of the national government, those are their powers. And if the Constitution doesn't mention those powers, then they are, if they're not delegated to Congress, then they are reserved to the states. If you recall, you remember this, the Venn diagram, federalism Venn diagram, we called them national powers, state powers, and shared powers, right? But if you're using the language of the Constitution, which we didn't, because I think it's simpler, I think it's easier and simpler to just call them national, state, and shared. But if you're using the language of the Bill of Rights, delegated powers, reserved powers, those are the state powers, and then concurrent powers. Like these are just fancier names for the same thing that we've already learned: national powers, state powers, shared powers. Okay, I think we're finally on number 12, which is the Hernandez family lives in a rapidly developing neighborhood. The city writes a letter to the family to inform them that their home is being taken by the government with compensation to build a new Walmart. Can the government do this? The answer is yes. The government is allowed to do this, and the Hernandez family has no grounds to sue. This actually, so first of all, you're like, Mr. Ippolito, this is ridiculous. What? Well, just for context, King John and other kings of England were seizing property all the time. Like it's throughout history, the government has from time to time had to seize property. And if you think about it, sometimes it just really makes sense, right? For example, if you need to build a freeway and it needs to go through like a certain city, then, and there's like one person's house or two people's houses or 10 or 20 people's houses that are right in the path of the freeway, and to try to go around a neighborhood would cost millions and millions and millions of dollars more to reroute a freeway and to go, like you have to, when you're designing freeway systems, you design the best, most direct path. And sometimes that goes through neighborhoods. And in Los Angeles and in other parts of the country, when the freeways were being built in the 1940s, 1950s, 1960s, that's exactly what happened. And sometimes you have to force people out of their homes because in the name of progress, right? The government, this is a compelling government interest because it is in the interest of the public. This freeway's got to go through your neighborhood. I'm sorry. You're going to get paid. You're going to get compensated for your house, but you're going to be forced to move out of it. And so this is a huge controversy. This was back in, I looked this up. This was the Kello versus City of New London case. This is in New London, Connecticut back in 2005. So just a couple years before you were born, this case happened. A very similar case happened where there were families that were kind of living in a rundown neighborhood. And the City of New London got an offer, like multi-billion-dollar offer from a land developer, real estate developer, saying, you know what? We'd love to put a shopping center like here. This is a good place for it. And the City of New London is like, well, we got houses there. And the real estate developer is like, yeah, but these houses, they're kind of run down. They're not really doing much for your city. But if we built a shopping center here, if we built a beautiful, shopping area, it would bring in a lot of revenue, a lot of tax revenue into the city. That would be a good thing for you. Just think about the millions of dollars that you could get every year just off of tax revenue from people coming and shopping, and people in town and people out of town coming and shopping in the shopping center. And the City of New London was like, oh yeah, you got a good point. Okay, we're kicking these people out. And this neighborhood was forced to leave, and there was a lawsuit, and that lawsuit went all the way to the Supreme Court, and the Supreme Court said, you know what? Sometimes it is in the government's interest. It's easy to see with a road or a freeway, but sometimes it's even in the government's interest to tear down people's homes to build a shopping center if it is going to be for the public good. And in this case, the Supreme Court determined that, in fact, it was going to be for the public good. So that private property, even though it was being sold to a private developer, it was still for the public good. And so they took people's homes, they gave them compensation for it, they paid them for it, but they had to get kicked out of their houses. Okay, well, hey, thanks for sticking with me, and thanks for learning all about these. Your next thing that you're going to do is you're going to do the other... you've done these scenarios. I have a few more scenarios for you to do for homework, so you can practice your Bill of Rights knowledge, and then we'll go over those when I see you in our next class. All right, thanks so much for sticking around and for learning about the Bill of Rights. Have a great day. Take care. Bye-bye. And now, you should be working on that next set of Bill of Rights scenarios. Okay, bye.